In this video, I'm going to talk about how to file a motion for counsel fees. So in a divorce or custody case, oftentimes one of the parties controls all of the money. And motion for counsel fees are most common in divorce cases versus custody cases. So in a divorce case, there, as I said before, there may be a situation where one of the parties controls all the money and the other spouse doesn't have any access to funds. In that situation, obviously, without the ability to ask for help from the court, the spouse that controls all the money would be at an advantage in that they would be able to hire an attorney and pay for an attorney while the other couldn't. So the court put some statutes in place to deal with that, which I will share my screen and show you. So Connecticut General Statute section 46B-62 says that in any proceeding seeking relief under the provisions of this chapter and section 17, so any family law type of case, basically, so divorce and custody are most common, the court may order either spouse, or if such proceeding concerns the custody, care, education, visitation, or support of a minor child, either parent. So what that's saying is a spouse if they're married, or a parent if it's a custody case, to pay the reasonable attorney's fees of the other in accordance with their respective financial abilities and the criteria set forth in a certain statute. So it's basically saying that the court will look at the financial abilities of the party. So again, if one party controls all the assets, the court is likely to grant a motion for counsel fees. Now, if you look a little bit further down in the statute, one thing that is important to note is that if the court determines that the father, mother, or an intervening party does not have the ability to pay such reasonable fees, the court shall not order that such reasonable fees be paid by such persons through the use of a credit card. So, I think the most common example is, a wife files a motion for counsel fees asking that, a husband pays her counsel fees. If you look at the financial affidavits of the parties and the husband doesn't have any assets and he, for example, put his own attorney's fees on a credit card, the court's not going to grant a motion for, or they're not likely to grant a motion for counsel fees, because if the husband put his counsel fees on a credit card, the court would say, all right, wife can put her counsel fees on a credit card also. And obviously the gender roles can be reversed, or there's often same-sex divorces. So but the court cannot order somebody to take on debt in order to pay the attorney's fees of the other. So to show you a sample motion, here is one such motion. This actually should probably say pendente lite here. So during litigation. So you just put pursuant to Connecticut General Statutes section 46B-62, which is the statute I just showed you, and section 25-24. So that's just a basic practice book section, Connecticut practice book section that talks about filing of motions. The plaintiff hereby requests that this court order the defendant to pay her counsel fees in connection with the above referenced matter. The defendant controls the family assets, and the plaintiff does not have the means to pay for counsel without use of the assets controlled by the defendant. And it doesn't necessarily have to be assets. It could be the income. In certain situations, a spouse may, earn, there may not be substantial assets from which to pay counsel fees, but one of the spouses may have a higher income than the other, in which case they can afford counsel fees. So the reality is that these motions are only generally granted when one party has no assets from which to pay counsel fees, or they have no liquid assets. If somebody filing a motion only has a 401k, for example, where there would be a penalty for an early withdrawal, that's obviously not ideal to pay a lawyer from a retirement account from which there will be a penalty. So if one party has no assets or no liquid assets, whereas the other may have a checking account with $15,000 in it or more, any amount, that could cover attorney's fees. In that situation, it's likely that the person who controls the money will be asked to pay a retainer for the counsel fees so that both parties have the ability to have counsel representing them. So that's kind of a general rundown on filing a motion for counsel fees in a family law case.